Welcome to This Explainer. Today, we're unpacking a deeply human story that essentially forced South Africa's highest court to define the very boundaries of marriage. This isn't just some dry academic legal debate. It's a profound look at what actually happens when the messy, lived reality of human relationships suddenly collides with the incredibly strict text of the law. We're going to be exploring the landmark constitutional court case of Volks versus Robinson.
Let's dive right in with a simple but honestly earth-shattering question about life, commitment, and legal definitions. Does a 16-year, deeply committed partnership actually equal a marriage in the eyes of the law, especially after one of those partners passes away? Well, to figure that out, we really need to look at the people at the center of this dispute.
We start by tracking the 16-year journey of Mrs. Ethel Robinson and Mr. Richard Shandling. Their relationship kicked off back in 1985. By 1989, they had moved into a flat together in Cape Town, sharing a really continuous, deeply intertwined life. Fast forward to the year 2000, and Mr. Shandling officially adds Mrs. Robinson as a dependent on his medical aid. But then, tragically, in late 2001, Mr. Shandling passed away.
Now, the depth of their bond was absolutely undeniable. Mr. Shandling provided a 5,000 Rand monthly allowance for household necessities. They shared mutual friends, attended social functions as a fully recognized couple, and Mrs. Robinson completely dedicated herself to nursing him through bipolar disorder and, eventually, his final illness. For all intents and purposes, they operated functionally as husband and wife, supporting each other both financially and emotionally. The only thing missing? The actual formal marriage certificate.
But here's where things get really complicated. When Mr. Shandling passed away, his estate was valued at a rather modest residue, about 413,000 Rand in total to be distributed. In his will, he affectionately referred to Mrs. Robinson as my friend, and he left her a car, the contents of their flat, and 100,000 Rand. The rest of his estate went to his 3 adult children from a previous marriage. But despite that bequest, Mrs. Robinson was left financially vulnerable, and so she sought ongoing maintenance from the deceased estate just to survive.
And bam, we hit a massive legal roadblock. The executor of the estate, Mr. Volks, flat out denied her maintenance claim. Why? Well, he looked strictly at the letter of the law, specifically the Maintenance of Surviving Spouses Act of 1990. The law explicitly protects a survivor, but under that act, a survivor is defined only as the surviving spouse in a marriage dissolved by death. Because she didn't have that official piece of paper, the executor said, "Sorry, your claim is invalid."
Now, Mrs. Robinson wasn't just going to accept that. She took the matter straight to the High Court, and her argument was fascinating. She argued her relationship met literally all the functional criteria of a marriage. She pointed to their absolute commitment to a shared household, their profound financial and emotional dependence, the massive 16-year duration of the relationship, and the mutual roles they played. Basically, she argued it was unfair discrimination based on marital status to deny her the exact same protections a legal widow would get.
And guess what? The High Court actually agreed with her. They ruled it was unconstitutional to exclude permanent life partnerships from the Act. The judge made a really beautiful point, stating that to ignore their arrangement would undermine the dignity of difference. The High Court was essentially saying, look, the law needs to respect different types of families, especially knowing how many South Africans live in domestic partnerships completely outside of formal civil or religious marriages.
Which brings us to the Constitutional Court majority, and their core focus: freedom to choose.
So the executor appealed this ruling, and the case made its way up to the Constitutional Court, where the judges were deeply split. The majority took a strictly impartial text-based view. They contrasted the two concepts, recognizing that marriage isn't just some social bond, it's a highly specific legal contract. Entering into marriage automatically triggers a massive set of legal duties, including the duty of support that extends past death. A life partnership, on the other hand, relies on duties that are explicitly and voluntarily chosen during life, but those don't just automatically carry over after death by operation of law.
Justice Squaya, writing for the majority, made a crucial point. He reasoned there was absolutely no legal impediment stopping Mrs. Robinson and Mr. Shandling from getting married. They could have, but they chose not to. He noted, marriage is not merely a piece of paper. By choosing not to marry, they actively chose not to take on those automatic legal consequences. Therefore, legally forcing the estate to pay maintenance would actually violate Mr. Shandling's freedom of choice and his right to distribute his property as he saw fit.
The majority concluded with this really foundational legal principle.
Yes, the law absolutely differentiates between married and unmarried couples, but that differentiation is not unfair discrimination. It is entirely appropriate, they argued, for the state not to impose a posthumous legal duty of support upon an estate when the couple themselves never formally undertook that legal duty while they were alive.
But there's another side to this story. Let's look at the dissenting perspective, vulnerability independence.
Several dissenting judges, including Justices Mogoro and O'Regan, pushed back hard with a totally contrasting philosophy. They highlighted what they saw as a severe, glaring gap in the law. Think about it. While legally married spouses are shielded by multiple laws, like the Intestate Succession Act and the Maintenance Act, ensuring they aren't left destitute, unmarried cohabitants have absolutely zero automatic statutory protection when a partner dies. If the deceased will doesn't provide for them, they are literally left out in the cold. And they pointed out that we aren't just talking about a fringe issue affecting a handful of people here. To put this into perspective, according to 2001 census data, 8% of the South African adult population, that was roughly 2.3 million people at the time, were living together as unmarried partners. The dissent argued that leaving such a massive slice of the population without any legal safety net upon the death of a partner is a widespread societal reality that the law simply cannot afford to ignore.
The dissent essentially said, look, when a relationship operates functionally as a marriage for over a decade, it inevitably creates deep structural dependence. In many of these setups, one partner, very often the woman, sacrifices her own financial independence to care for the home or the other partner. Failing to protect these vulnerable individuals, who have built entire lives of dependence outside of formal marriage, constitutes unfair discrimination based on marital status.
So, what's the broader impact here? It reveals a divided court and a deeply complex society.
Ultimately, this case showcased a constitutional court that was right down the middle, perfectly reflecting the profound tension in modern society between incredibly strict legal definitions and the messy, nuanced reality of human relationships. The final outcome? The majority ruled and the High Court's decision was overturned. The Maintenance of Surviving Spouses Act was upheld as strictly applying only to legally recognized marriages. That meant Mrs. Robinson could not claim the spousal maintenance she so desperately sought, but it ignited a massive ongoing debate about family law reform that continues to this day. As we wrap up this explainer, I want to leave you with this final, truly provocative thought. Should the law automatically protect those who act like spouses, even if they never actually sign the marriage certificate? It forces us to ask what matters more to the state, the formal choice to sign a legal contract or the lived, breathing reality of love, sacrifice, and mutual dependence. It is a fascinating intersection of love, choice, and the rigid text of the law. Thanks for joining me, and I encourage you to keep questioning how the law shapes the very lives we choose to live.